The Supreme Court Constitution Bench on Monday, by a 4:1 majority, upheld the decision taken by the Union government 6 years ago to demonetize the currency notes of Rs 500 and 1000 denominations. The majority held that the centre's notification dated November 8, 2016 is valid and satisfies the test of proportionality. Justice B.V. Nagaratna, in her dissenting view, however, held that though demonetization was well-intentioned and well thought of, it has to be declared unlawful on legal grounds and not on the basis of objectives. The five-judge bench, comprising Justices S. Abdul Nazir, B.R. Gawai, A.S. Bopanna, V. Ramasubramanian and B.V. Nagaratna, was answering a division bench reference. It had reserved the judgment on December 7th last year. The matter is now sent back to the division bench. We have also made a detailed video on the arguments that were advanced during the hearings, the link to which has been given in the description box below. Please do check it out. The majority yesterday underscored that the question whether the measure has achieved its objectives, such as eradicating black marketing, terror funding, etc., is not relevant while deciding its legality. The majority further held that the prescribed period of 52 days for currency exchange is also not unreasonable. Quoting from the majority verdict, it is not relevant whether the objectives sought have been achieved or not. What is required is that there has to be an objective which is for proper purposes, and there has to be reasonable nexus with the measure and the objectives. Accordingly, the majority verdict states that curbing fake currency, black money and terror funding are legitimate interests of the state and have a rational nexus with demonetization. The majority also pointed out that there existed no alternative measures that could have achieved a similar purpose with a lesser degree of harm for citizens. Pertinently, the majority also held that the decision-making process cannot be faulted merely because the proposal emanated from the central government, and emphasized that there has to be great restraint shown in matters of economic policy and that courts cannot supplant the wisdom of the executive with its wisdom. While addressing the contentions raised by the petitioners that on account of such a hasty decision of demonetization by the central government, citizens had to suffer at large and that many people had to stand in queues for hours and were also deprived of food and livelihood, the majority underscored that merely because some citizens have suffered hardships, it cannot be concluded that the decision was taken in a hasty manner. Quoting from the majority decision, the contention that the impugn notification is liable to be set aside on the ground that it caused hardship to individual citizens will hold no water. The individual interest must yield to the larger public interest sought to be achieved by impugned notification. Highlighting that the demonetization decision cannot be attacked for having been done in haste, the majority also remarked, and I quote again, "Such measures undisputedly are required to be taken with utmost confidentiality and speed. If the news of such a measure is leaked out, it is difficult to imagine how disastrous the consequences would be. Confidentiality and secrecy in such sort of measures is of paramount importance." On the other hand, however, Justice B.V. Nagaratna, in her dissenting view, held that demonetization of the whole series of Rs 500 and 1000 currency notes is a serious matter and that it cannot be done by the centre by merely issuing a gazette notification. She highlighted that although the measure was well-intentioned, it has to be declared unlawful on legal grounds and not on the basis of objectives sought to be achieved only. Pointing out that the demonetization decision of the centre may not have been as effective as it had been hoped, Justice Nagaratna observed in her dissent, and I quote, "It has also been brought on record that around 98% of the value of the demonetized currency notes have been exchanged for bank notes, which continues to be a legal tender. Also, a new series of bank notes for Rs 2000 was released by the bank. This would suggest that the measure itself may not have been proved to be as effective as it was hoped to be. However, this court does not base its decision on the legality of a legislation qua the effectiveness in achieving the stated objectives. Therefore, it is clarified that any relief molded in the present case is divorced from the consideration of the success of such measures. Also underscoring that such a measure must be undertaken through legislation, Justice Nagaratna highlighted that demonetization of all series of notes at the instance of the central government is a far more serious issue than the demonetization of particular series by the bank. The judge further expressed that the RBI did not show an independent application of mind and merely approved centre's desire for demonetization and accordingly held, and I quote again, "On looking at the records submitted by RBI, there are words as desired by the central government. This demonstrates that there was no independent application by the RBI. The entire exercise was carried out in 24 hours. Justice Nagaratna in her dissent also wondered if the central board of the RBI had visualized the consequences that would follow such a decision and accordingly ruled, and I quote from her dissent here, "The problems associated with the measure of demonetization would make one wonder whether the central board of the bank had visualized the consequences that would follow, whether the central board of the bank had attempted to take note of the adverse effects of demonetization of such a large volume of banknotes in circulation. The objective of the central government may have been sound, just and proper, but the manner in which the said objectives were achieved and the procedure followed for the same, in my view, was not in accordance with law, having regard to the interpretation given above." On the issue as to whether Section 26 subsection 2 of the RBI Act, which empowers centre to demonetize any series of banknotes of any denomination, can be used to demonetize the whole series of currency, the majority ruled, and I quote here, "Restrictive meaning cannot be given to word any in Section 26 subsection 2 of RBI Act. The modern trend is of pragmatic interpretation. Interpretation which leads to absurdity must be avoided. The purposes of the Act must be considered while interpretation." The majority added that Section 26 subsection 2 cannot be struck down as unconstitutional on the ground of excessive delegation, adding that there are inbuilt safeguards since the central government is required to take a decision only after consulting with the central board of the RBI. However, disagreeing with this majority view, Justice Nagaratna held that any series under Section 26 subsection 2 of the RBI Act cannot mean all series, and accordingly noted, and I quote, "Section 26 subsection 2 can be only for a particular series of currency notes and not for the whole series of currency notes of a denomination." Next, the judge held that the RBI Act does not envisage initiation of demonetization by the central government. As per Section 26 subsection 2, the proposal for demonetization is to emanate from the central board of the RBI, she said. Justice Nagaratna further held that if demonetization is to be initiated by the central government, such power is to be done through a legislation or an ordinance derived from entry 36 of List 1 of the Constitution, which speaks of currency, coinage, legal tender and foreign exchange. For more information on this ruling, you can refer to our detailed reports, the link to which has been given in the description box below. Thank you. I'm Aratrika Bhaumik for LiveLaw. Keep watching LiveLaw for more such updates.